Here is an important matter about juvenile justice. The name of the matter is State of NCT versus K. The matter in front of the court was whether trial proceedings of a child alleged to be in conflict with law and a person, not a child, that is, an adult, could be held jointly. After a preliminary assessment of Juvenile Justice Board declaring the child in conflict with law to be psychologically and physically mature is the question that has come up for consideration before this court in this petition. The present revision petition has been filed by the petitioner CCL to set aside order dated 23rd May 2022, impugned order passed by the trial court ASJ 6 West 30,000 Court, Delhi, dismissing the application of the petitioner under Section 23 of Juvenile Justice Care and Protection of Children Act 2025, that is JJ Act, whereby the petitioner sought to stop the ongoing joint proceedings trial of the petitioner with adult accused Mr. Vivek Kumar in connection with FIR number 418 by 2006 under Section 186, 353, 302, 24 IPC at PS Nangloi. Factual background. As per the case of the prosecution on 26 September 2016, information was received at police station Nagloi and the same was entrusted to SI Mahesh Kumar, who along with the staff reached the spot, that is Government Boys Senior Secondary School, Sultanpuri Road, Nagloi, Delhi. On reaching the spot, it was found that there was a lot of blood scattered at the main gate of the school and also in classroom number 108. Upon inquiry, it was revealed that the injured teacher, Mr. Mukesh Kumar, had already been taken to Sri Balaji Hospital in Paschim Vihar, Delhi. On reaching the hospital, the injured teacher was found to be admitted wide MLC number 6314/16, in which alleged history was written as assault by sharp weapon at around 5 p.m. at Government Boys Senior Secondary School, SP Road, Nagloi, by two school students, Vivek and Master K. In the hospital, eyewitness SH Badan Singh, complainant, who is also the vice principal of the school, got the injured teacher admitted in the hospital and handed over this complaint to SI Mahesh Kumar, in which he alleged that Vivek Kumar Jha is a 12th class student and Master K is also a 12th class student, whose name was stuck off being an absent, and their class teacher was Mukesh Kumar, PGT Hindi. Both students had threatened Mukesh Kumar as they felt that Master K's name was struck down because of their class teacher. On the day of the incident on 26 September 2016, when teacher Mukesh Kumar was found, counting the answer sheets in the classroom 108, the complainant heard hues and cries and spotted the two students, namely Vivek Kumar and Master K, running from the stairs. He proceeded to catch them but was unsuccessful as they ran from the school after jumping over the wall. On reaching the classroom, the teacher Mukesh Kumar was found there lying in seriously injured condition. On the basis of the same, the present FIR came to be registered and investigation was taken up. During the course of treatment, the injured teacher was declared dead by the doctor at Sri Balaji Hospital, Paschim Vihar, Delhi, at Section 302 of Indian Penal Code 1860 was added in the case. On 27th September 2016, the accused Vivek Kumar, aged 19 years, and accused Master K, aged 17 years, were apprehended and clothes worn by them were seized and taken into possession. On the instance of accused Vivek and weapon of the offense, that is knife, and on the instance of Master K, punch used by him was recovered. Documents relating to the age of the accused were verified from Government Senior Secondary School Sultanpuri Nagloi, according to which the date of birth of CCL is 29th October 1998 and co-accused Vivek is 25th February 1998. The charge sheet was filed by the concerned IO. The board, in its assessment wide order dated 9th January 2017, opened that here there is a need for trial of the CCL as adult offender and on the basis of the opinion of the case was transferred to the Children's Court for trial. The order of the board dated 9th January 2017 was challenged by petitioner in appeal before Sessions Court and the same was dismissed by order dated 3rd June 2017. Thereafter, petitioner, being aggrieved by the outcome of the appeal, preferred a revision petition being CRI Revision P 961 2017, which was dismissed and as withdrawn by order of this court dated 10th December 2024. Pursuant to the dismissal of the appeal, the case of petitioner was sent for initiation of trial and by order dated 24 September 2018, the charge sheet for both adult accused, that is Vivek Kumar and CCL, were tagged together and by order dated 9th December 2018, charges were framed against both adult accused and CCL. The trial is presently at the stage of prosecution evidence, and about 24 out of 30 witnesses have been examined so far. Submission. On behalf of the petitioner, counsel for the petition has raised inter alia the following contentions. On the issue of moving the application belatedly, counsel for petitioner submits that the application was moved in 2022 and claim of juvenility may be raised at any stage even after the final disposal of the case and that delay in raising the claim of juvenility cannot be ground for rejection of such claim and places reliance on the decision in Abuzar Hussain versus State of West Bengal 2012 10 SCC 489. Counsel for the petitioner submits that Section 23 of JJ Act overrides all other laws and places reliance on the decisions in Kanailal Sur versus Paramnidhi Sadhu Khan 1957 SCC online SC 8 and Pintu Suresh Bhai Prajapati versus State of Gujarat R SCA number 8101 2019 decided on 16/6/2021. He submits that the plain meaning of Section 23 of JJ Act bars joint proceedings, including trial of CCL, without adult offenders, and there is no statutory provision that suggests a contrary interpretation. He also places reliance on CCLA versus State of NCT of Delhi bail application number 2510/2020 decided on 19/10/2020 and submits that even when a child is spent up for trial as an adult before a children's court, the child does not become an adult or major but is only to be declared differently considering the heinous nature of the offense alleged, though still as a child in conflict with law. Petitioner's counsel argues that impugn order that after examination under Section 19 of JJ Act, a CCL would be tried along with an adult. which is a contrary to the language used by the legislature, tried as an adult, as opposed to tried with an adult. He submits that the trial court's interpretation would render several provisions of JJ Act and nullity as Section 23 of Act prohibits joint proceedings of a CCL and adult offender together and not just joint trial. While placing reliance on the decision in Babu Lal versus Hazari Lal Kishori Lal, 1982, 1 SCC 525, he submitted that the word proceeding has much wider meaning than the word trial. Counsel for petitioner argued that as per K.H. Nazar versus Matthew K. Jacob and others 2020-14 SCC 126, the Supreme Court has held that provisions of beneficial legislation must be construed with a purpose-oriented approach and that in Pratap Singh versus State of Jharkhand and another 2005 3 SCC 551, the Supreme Court considered the preamble, the statement of object and reasons of the JJ Act and concluded that it was a beneficial legislation and ought to be interpreted to the benefit of those whom it is made. He also argued that in view of Section 18(3) of JJ Act, only a children's court can conduct trial of a CCL and a sessions court does not have the jurisdiction to conduct the trial of a CCL. He further argued that the petitioner has been and continues to be prejudiced on account of having been tried with an adult while placing reliance on the decision of Mumtaz Ahmad Nasir Khan versus State of Maharashtra and others, Criminal Appeal number 1153 of 2018, decided on 15/7/2019, wherein the Bombay High Court explained the difference, finding that a trial before a children's court is offender oriented, whereas a trial in a regular court is offense oriented. He submits that the joint trial proceedings are prejudicial to the rights and interests of a CCLK at every stage of the trial, including framing of charges against CCLK and the adult co accused jointly, white order dated 19 December 2018, which is in complete violation of the principle of non stigmatizing language enshrined in Section 3 of 8 of JJ Act, principle of non stigmatizing semantics. He also submits that the name of CCLK has been repeatedly used in various orders passed by the trial court, which is complete violation of Section 3 of 9 of JJ Act, principle of right to privacy and confidentiality. Counsel for the petitioner submits that special treatment of CCLs during judicial process, such as trial, has been recognized by various authorities, committees, and government bodies as illustrative. Few are as under the National Policy for Children 2023. This was adopted by the Government of India in 2023 and postulates the best interest principle as the primary consideration for all decisions and actions affecting children taken by courts of law and casts a duty on the state to ensure that justice delivery mechanisms are participatory, responsive, and child sensitive. Counsel for petitioner placed reliance on clause 3 of 7 and 5.4, which are extracted as under guiding principles. 7. The best interest of child is a primary concern in all decisions and actions affecting the child, whether taken by legislative bodies, courts of law, administrative authorities, public, private, social, religious, or cultural institutions. The state shall ensure that service delivery and justice delivery mechanisms and structures are participatory, responsive, and child sensitive, thereby enhancing transparency and ensuring public accountability. Synergistic linkages will be created with other progressive and successful experiments to learn from best practices across regions. The report of the National Annual Stakeholders Consultation on Child Protection 2023. This was organized by the Supreme Court, Juvenile Justice, and Child Welfare Committee, noting the demanding effect that formal proceedings of the judicial system can have on the mental and physical well being of children, with one of the key recommendations being intensifying focus on embedding child friendly processes and procedures. Relevant extracts are as under. Participants agreed to intensify focus on embedding child friendly and gender sensitive justice processes and procedures and strengthen cooperation between justice, child protection, and allied system. The High Court Juvenile Justice Committees and the nodal departments have additionally identified respective state priorities under the four areas of focus on the basis of the engagements organized as a lead up to the national consultations. The guidelines for public officers of the Special Juvenile Police Unit issued by the Juvenile Justice Committee. The guidelines provide for a child friendly manner if what would otherwise be considered custodial interrogation in the form of an interview in suitable premises. A child in conflict with law is presumed to be innocent until proven guilty according to law, and therefore should not be compelled to confess guilt. As far as possible, child in conflict with law should be interviewed at a premises which does not give feel to the child of being in police station and or under custodian interrogation. If parents of the child in conflict with law so desire, then the child may be interviewed at his home. The summary of such interview shall be recorded in the form of the version of the child in conflict with law. And in case the same reveal that the child has been subjected to any neglect, abuse, ill treatment, etc., by anyone forcing the situation of conflict upon the child, then necessary action should be immediately initiated against preparators of such acts. Counsel for the petitioner submits that it is clear from the language of Section 19(1)(1) of JJ Act that the intention is not for the trial of CCL to resemble the trial of an adult in all material aspects. And on the contrary, the JJ Act provides that such a trial ought to be conducted in a child friendly atmosphere, that is, in a manner that is humane, considerate, and in the best interest of the child. He states that while there are no definitive guidelines on what constitutes a child friendly atmosphere to be maintained by a children's court, various states, international organizations, and courts have provided guidance on what the features of such trial would be. Some illustrative examples are as under. Number 1, that is 18.1, Madhya Pradesh Juvenile Justice, Care and Protection of Children Rules. Number 2, that is 18.2, the draft Karnataka State Juvenile Justice, Care and Protection of Children. Number 3, 18.3, Model Law on Juvenile Justice issued by the United Nations Offense on Drugs and Crime in 2013. Number 4, 18.4, in Anand Kumar Asthana versus Union of India, and another titled Writ Petition C 787 2012, decision dated 5th November 2024, a coordinate bench of this court issued guidelines requiring courts to obliterate details leading to the disclosure of identity of a child from judicial proceedings before issuing certified copies, and directed that the child's identity and related details will not be disclosed to anyone. Number 5, the guidelines for establishment of child friendly police stations. Number 6, Section 33 of Protection of Children from Sexual Offences Act 2012, that is POCSO Act. Submissions on behalf of states. The APP submits that impugned order dated 23rd May 2022 cannot be subject matter of revision before this court, as under challenge is essentially in the nature of review and is barred by section 362 of the Criminal Code, Procedure Code, which prohibits the review of orders passed by a criminal court. He states that the application filed under Section 23 of JJ Act was merely a request for a review of the clubbing of trials of the co-accused Vivek Kumar and CCL, and as such it was not maintainable. The APP placed reliance on the decision in Salil Bali versus Union of India and another 2013 7 SCC 705, where while rejecting the petition seeking a re-evaluation of certain provisions of the JJ Act 2000, the Supreme Court held that any changes to the classification of juveniles were matters for legislative decision and the judiciary cannot intervene in this domain. He also placed reliance on Shilpa Mittal versus Government of NCT of Delhi 2022 SCC 787 to state that before the juvenile justice is to be tried as an adult, a very detailed study must be done and the procedure laid down must be followed. Even if a child commits a heinous offense, he is not automatically to be tried as an adult, which indicates that the meaning of the word heinous offense cannot be expanded by removing the word minimum from the definition. The APP submits that the trial in respect of the petitioner and co-accused should be allowed to continue in the children's court. He submits that the objectives of the JJ Act aim to distinguish between children who should be treated as juveniles and those who should be treated as adults. He submits that the interpretation of Section 23 of JJ Act in line with the legislative intent indicates that the term CCL is understood to exclude children who have been directed to be tried as adults. He states that the correct interpretation of Section 23 JJ 2015 is that Section 23(1) would prevent the trial of a CCL who has not been directed to be tried as an adult alongside a major accused. Section 23 of 2 would then apply specifically to a child who is now directed to be tried as an adult, and it would mean that if during proceedings the JJB or Children's Court found that the child is now directed to be tried as an adult, his proceedings cannot be concluded with a child not to be tried as adult. He states that children who are not to be treated as adults would not face a joint trial with either major accused or a child. who has been directed to be tried as an adult. He submits that the interpretation of Section 23 of JJ Act allows for a major accused and a child who has been directed to be tried as an adult to be tried together in children's court, as the children's court is competent to try both adults and children under its jurisdiction. He further states that there is no statutory bar preventing the children's court from trying a major accused along with a child who is being treated as an adult, whereas in contrast, JJB lacks the jurisdiction to try major accused persons as it is limited to matters involving children. He also submits that potential harm could arise from conducting separate trials for a child who has been directed to be tried as an adult and a major accused in the same case. He states that multiple trials could lead to contradictory testimonials, inconsistent judgments, difficulties for independent witnesses. All of such could undermine the integrity of the judicial process. He also submits that the joint trials involving both children and adults are permitted under specific conditions in Queensland, Australia, and Hong Kong. He lastly submits that the JJ Act was designed to safeguard the rights of children. However, the law expressly creates exceptions for certain children to be treated as adults under Section 19(1)(1) of JJ Act 2015, and these exceptions must be respected in the interest of justice. The JJ Act recognizes a more stringent approach for children who commit heinous offenses and has provisions to direct them to be tried as adults subject to the mental and physical conditions. Now the analysis. By concluding the matter after detailed analysis, the court reached to an opinion that is as per plain reading of Section 23 of JJ Act and even by the the section given above, there can be no doubt that joint trials ought not to be held between a child in conflict with law being tried as an adult and an adult offender. In the case at hand, post the preliminary assessment under Section 15 JJ Act by the board, the CCL has been tried before a children's court, and to that extent, his right has not been compromised. The only issue arises that the adult offender also is tried before the same sessions judge who is designated children's court, though the trial would involve effectively the same set of witnesses and revolve around the same issues. Section 23 of JJ Act prohibits the same, and there ought to be a separate set of trials for both. Considering that the case of CCL was transferred to the Children's Court by the order dated 9th January 2017, which was subsequently challenged and plea was rejected, the trials have been clubbed together and the case of the adult co-accused was transferred to the Children's Court as well. The charges were tagged together by the order dated 24 September 2018 and charges were framed jointly by order dated 19 December 2018. The challenge to the order of joint proceedings was then again sought to be displayed by the application under Section 23 of JJ Act, which was moved by petitioner and was dismissed by the ASA by impugned order dated 23rd May 2022. The petitioner's counsel, Mr. Asim Sood, was, however, categorical in his plea and concedes that he is not seeking the trial to be stated de novo since much time has passed and trial has continued, but at least it ought to split from the point where it stands. It is stated that only 5 to 7 witnesses are left to be examined, and though can be examined together on the application of Section 23 of JJ Act, the trial should separate even though it is being conducted by the same sessions judge sitting as a sessions court and as a children's court. Even though at first blush, this may seem like an unnecessary exercise, it would sanitize the process and bring it in consonance with the provisions of the Act and in tune with the legal mandate. Considering the prohibition is to joint proceedings, there can be no doubt that the CCL must be tried independently from the adult offender and the recording of the evidence relating to the rest of the witnesses and the final tail end of the trial, including the arguments, ought to be conducted independently. Accordingly, the revision petition is allowed, the impugned order is set aside to the extent that the trial of the petitioner CCL going onwards would be held separately from the adult co-accused, that is Mr. Vivek Kumar Jha. Pending applications, if any, are rendered infructuous, the judgment be uploaded on the website of the court. Thank you.